Hello, everyone, and welcome. We'll get started here in just a minute to allow all attendees to filter into the webinar. Well, hello again, and welcome to the Economic Innovation Group's first webinar in our American Dynamism series on the case for non-competes reform. My name is Catherine Lyons. I'm the Director of Policy at EIG, and thank you so much for being here. I'll go ahead and kick off as we're waiting for more attendees to join by starting with a little bit of background on EIG. So we are a bipartisan research and public policy organization based here in Washington, D.C., with a mission to advance solutions that empower entrepreneurs and investors to forge a more dynamic American economy. EIG has helped illuminate the harmful impacts of non-compete agreements on American workers across the country, including through original research we published in 2019 by University of Maryland professor Evan Starr. We've since and continue to work closely with Senators Chris Murphy and Todd Young's offices to introduce the Workforce Mobility Act in fall 2019, which was also introduced in the House by Representatives Peters, Gallagher, and Eshoo in 2020. Just in February of this year, the Workforce Mobility Act was reintroduced in the 117th Congress with more bipartisan sponsors in both chambers. We believe this reform is urgently needed, especially in light of the economic disruption caused by the COVID-19 pandemic. So today we will hear from Senators Murphy and Young directly in a pre-recorded discussion with John Lettieri, EIG's president and CEO. We will then transition to the live panel portion of our webinar with guest speakers Rachel Arnow-Richman of the University of Florida Levin College of Law, Najah Farley of the National Employment Law Project, and Eli Lehrer of the R Street Institute, moderated by Jordan Weissmann of Slate. We hope to have a few minutes towards the end of the webinar for our live panel to answer questions from the audience submitted in the Q&A function. So please submit questions there, again, in the Q&A function, not the chat, if you wouldn't mind, as you have them. This webinar is being recorded. We will post the recording with a recap of the conversation on our website shortly after the event concludes. So without further ado, we'll get started by hearing from Senators Murphy and Young. And thanks again for joining.
Good afternoon, everybody, and thank you all for joining us today. I'm John Lettieri, the head of the Economic Innovation Group, and I'm very pleased to be joined by Senators Chris Murphy and Todd Young for today's discussion. If you know anything about non-compete reform, these are two senators who need no introduction, but I'm going to give them a brief one anyway. Senator Murphy has represented the state of Connecticut in the U.S. Senate since 2013. He currently serves on the Help Committee and the Appropriations Committee, among others. Senator Todd Young represents the great state of Indiana. He currently serves on the Senate Finance Committee and the Small Business and Entrepreneurship Committee, among other assignments. Senators, thank you for joining us for this important discussion. So the two of you have been at the forefront of a bipartisan bicameral effort to reform how non-compete agreements can be used to limit worker mobility throughout our labor market. So Senator Murphy, maybe you could start by briefly explaining the rationale for the Workforce Mobility Act. What would it do? Why should non-compete reform be a priority in Congress today?
Thank you very much for having both of us. Thanks to the Economic Innovation Group for the great work you've done to sort of midway through the argument around why non-competes are holding our economy back and workers back. And I'm glad to join with my friend Todd Young on this effort. I think you are right. We are buoyed by how much bipartisan support we have for this measure, especially if we get into a conversation about the next iteration of workforce training policy. We hope that we can be able to put this on the table. Listen, from my perspective, we have to understand what the future of the American economy looks like, and it is an economy that is going to have to be driven by innovation. My state is one in which we have cities whose entire identity was wrapped up in the thing that they made for the last 200 years. We have the silver city, the hat city, the brass city, the hardware city. We don't make a lot of silver, brass, hardware hats in Connecticut any longer, but we're developing researching the next iteration of all of those technologies. And so our economy is going to be one, not necessarily in which we're doing high scale, low value added manufacturing. We're going to be an economy that's researching, developing new products, doing manufacturing that involves a high value add. And so that means we've got to be doing everything possible so that we're promoting both innovation and entrepreneurship. And these non-compete agreements, first and foremost, restrain innovation, because if you are tied to your place of employment and you cannot leave to go bring an idea you have into fruition, it harms all of us. It harms all of us. And so if we want to be a startup economy, we've got to grapple with the fact that, especially when you're talking about folks that work in technology fields, by some estimates, almost half of them, or sometimes more than half in certain fields, are essentially bound to their employer, because if their employer can make any kind of claim that the business that they're starting is in any way, shape, or form competition with the business that they are in, they're just going to stay where they are. But this is not just about folks who are going out and starting their own business. These non-compete agreements are now increasingly being used in lower income fields. I hear about it all the time in home healthcare. So home healthcare aides, these are really important jobs, but they are by and large lower skilled jobs, increasingly have non-compete agreements, because these workers don't have a lot of leverage when they sign up to take the job. They by and large don't know that there's a non-compete agreement in there, but it allows for the employer to keep wages down, because they have no fear that that individual is going to go work for another healthcare agency. And so it's about innovation, it's about worker mobility, it's about putting real pressure for pay increases. And I'm glad that it's something that now, is increasingly uniting Republicans and Democrats, and I'm really glad to, have Todd as a partner.
Well, thank you, John. Thank you to EIG for all the support that you've provided to my colleague Chris Murphy and I, and now others who have joined this effort to eliminate non-compete agreements across the country. Let me go a slightly different direction. I agree with everything Chris said, and he spoke to a great extent about the economics of this and the need to catalyze innovation, which elimination of non-competes will do. It will lead to more startups. It will lead to, of course, more innovation. But eliminating these agreements or constraining their use significantly just aligns with our fundamental principles, our American values. Each of us aspires to harness our God-given gifts and apply them to their highest and best use in a vocational setting. It's how we give meaning to our lives. It also, incidentally, happens to be how we provide the most value to our neighbors, to our economy. It leads to a greater rate of economic growth, which benefits all Americans. And so what I'm hearing back home right now is there's a real mismatch between the skills that are required in our economy on one hand and the skills that people have on the other. And to the extent we can liberate people to leave one labor setting and go into another where they are adding more value or frankly pursuing their own passions, that seems very much consistent with the American ethic and the American dream. I think it's also really, we shouldn't undersell the extent to which employers will benefit from this change. We've seen this in Oklahoma and North Dakota and Silicon Valley, all places with vibrant economies, but very dissimilar economies. And both workers and employers value this prohibition on non-competes because it provides flexibility within our labor markets, and the freedom to leave is an incredibly fundamental concept that I think is really baked into the very DNA of every American.
You drill down on that a little bit further, because I think the debate around non-competes is often framed as If workers are benefiting, employers must not be benefiting from this. But how do employers benefit when non-competes are not part of the picture in the labor market?
Well, employers benefit because number one, and Chris touched on this, through innovation. After all, ideas are developed and innovation occurs when you take one idea or concept or finding and pair it with another. It's through that process of synthesis that innovation has historically occurred. And sometimes those ideas reside in different individuals. So when you have more churn in your labor market, it leads to more innovation within these enterprises that, of course, employers and managers care very much about. But just more broadly, having a higher rate of economic growth and creating an innovative ecosystem also benefits our employers. And then lastly, let's talk about probably what is most on our mind when we talk with employers these days. It's the lack of a qualified labor pool to fill all of their various needs. That much of it was pandemic induced, but candidly, we in the state of Indiana, the most manufacturing intensive state in the country, we're experiencing many of these challenges headed into the pandemic because the rate of economic growth was very high. People's wages were rising, and yet many employees were trapped into a particular employment circumstance that was either stale or non-stimulative to them personally, or it was just not allowing them to add as much value to the economy as they would have otherwise been able to. So there are multiple ways, I think, in which employers can and will benefit from this change.
John, can I just add? It's hard often, especially in industries with high penetration of non-compete agreements, to act unilaterally. If you're in an industry where 30 or 40% of your competitors have non-compete agreements, were you to decide not to enforce non-compete agreements or include them in contracts, you would obviously risk those employees leaving while not necessarily getting the benefit of greater labor fluidity in the marketplace. And so it is certainly a problem of the first mover. And again, as Todd mentioned, we've seen this in states that have made the decision to create a level playing field. Everybody benefits, but this is an area of the law in which there is a benefit to sort of a common decision being made about whether we're allowing them or whether we're prohibiting them, because it's difficult for individual companies to do them themselves.
One final point, if I could just add, I think that every American should be able to agree that in the midst of a pandemic-induced economic downturn, when employers did everything they could to keep some of their valued employees on the payroll, but in the end had to lay them off just because they couldn't make the dollars and cents work, those employees should be afforded the opportunity to fill spots elsewhere. But non-compete agreements, I don't think most Americans would appreciate, prohibited people from taking jobs. Much needed jobs in the middle of this global pandemic. So this is an extreme circumstance illustrating just how harmful these non-compete agreements can be to employers who need those workers, but also to the employees whose morale is undermined, whose skill sets erode during times between employment. And this is something we need to remedy on their behalf.
We've seen a bumper crop of interest and new legislation at the state level and at the federal level in recent years on this. You all have been working formally together since 2019. And even just in that time period, we've seen this bevy of legislative interest from both parties. And it's fair to say that you two come to this issue from different points of view, broadly speaking, on economic policy issues, but have arrived at a very coherent destination on this legislation. What do you think it is that's turning the tide? Is it the research and data? Is it the stories and testimonials from individual workers who have been harmed by this? why do you think that this issue has really been thrust into the spotlight in this way? And in the post-COVID context, what are you expecting to see and hear from your colleagues as you start to do more evangelism on this issue? And as Senator Murphy noted earlier, hopefully get it into an upcoming legislative package.
I mean, I can start. Listen, I think it's not lost on Congress that these agreements are becoming more widely used. And so as they're more widely used and more people are hearing about them, I also think that the research and the education around this issue has made a difference. I will say that, for much of, I'm a late convert to this issue. I think for much of, my time in public service, I had assumed that these agreements were, exclusive to high-tech industries and essential to the protection of intellectual property. And as I learned, there was increasing penetration of these agreements in low-scale jobs, and it was pretty easy to understand how other law, like the intellectual property theft law regime, adequately protects IP. You don't need this in order to make sure that somebody doesn't steal a trade secret. So I think it's the education, I think it's the proliferation of the agreements, and then I think it's the fact that there's so many on-ramps to this issue, right? Come at it from a workers' rights standpoint, you come at it from an entrepreneur standpoint, you come at it if you're concerned about the free market and the lack of constraints on that free market. So I just think there's a lot of sort of directions that you come and arrive at the same issue. That's why we've got a group of co-sponsors here that probably don't see eye to eye, other economic policy or workforce policy, but this one, makes some bedfellows.
I would agree with Chris. I think the compelling personal testimonials we hear from individuals who are either trapped in a particular job or were trapped in a particular job, those low-wage workers, most especially, that's caught a lot of media attention. And we've had a number of allies in this effort in making sure that the media was attentive to these compelling stories, EIG among them. And then members of Congress, Senator Murphy, myself, and others have tried to amplify the importance of this issue. And, I think we're also increasingly acknowledging, not just at the policymaking level, but members of our business community and many of our constituents, that we are in a global competition. We're in a global competition for economic growth and jobs and a competition of values. And so we're being called to ensure that America rises to this challenge as we did during the Cold War and becomes a better version of ourselves. And in order to do that, we're going to have to optimize a number of our laws. And if you have a law in place here or a lack of constraints, as the case may be, that depresses wage growth, that constrains innovation, that inhibits career advancement, especially for the least among us, and that leads to less business creation at a time when we need more startups. We see the trend lines going downward and have for roughly 3 or 4 decades in terms of startup creation. Then it's time to act boldly and quickly. And that's why I'm hopeful that this Congress, we might find a path to victory.
Senator Murphy, something I know you've been following closely is the broader effort on workforce development. And so I want to talk about how this is a complement to that kind of an effort. Two of your colleagues, Senator Murray and Senator Burr, recently announced their bipartisan effort to update and expand workforce development programs. And part of that effort includes improving workforce training in direct relation to the pandemic and advancing strategies that encourage innovation. So could you explain how you see this issue of non-compete reform working as a direct complement to that effort, especially as American workers are starting to rebuild from the coronavirus-motivated job crisis, and as we start to think about what the economy needs to look like in a post-pandemic universe?
Yeah, I in part would refer back to my prior answer around how removing non-compete agreements does help stimulate an innovation economy. If we want to grow the economy, we have to have new companies. It is fairly alarming how the overall sort of trend line of startups in America has slowed. And there's a lot of reasons for that, but one of them, I believe, is that it's just a little riskier today to try to leave your place of employment, in part because what happens in these non-compete agreements is that, it's often a matter of debate as to whether you are in violation, but the mere threat of legal action from your employer, whether the agreement is enforceable, or whether or not your future business endeavor is actually in conflict with that agreement. The mere threat of enforceability or legal action is often enough to shut down an individual from leaving and starting up their own company. So, if we want to recover post the pandemic, we need to have a healthy startup economy. But two other pieces of this: there are some non-competes that apply whether or not you leave voluntarily or are laid off. There are some non-competes that continue to constrict you from getting employment, even if you have been furloughed. And so, in an economy with a lot of people furloughed, laid off, you have to consider the particular impact of non-competes. And then finally, the lion's share of impact in the last year economically has been on women. It's primarily been women that have been in the workforce. I've seen some data that suggests the economic impact of non-competes are a much heavier burden on women rather than on men, in part because a lot of these lower skill jobs like home healthcare that have a lot of non-compete agreements tend to be staffed by women. So as we sort of try to make sure that women who have been disproportionately harmed economically in the pandemic have an on-road back to economic success, I think this is part of that package.
That's great. And a related point is you talk about the disproportionate impact on women. One of the things we've seen during the coronavirus crisis is obviously that crisis is hitting communities and individuals nationwide, but the effects have been disproportionately borne by certain types of communities and demographic groups. We see the same type of thing in the literature on non-competes, where non-competes disproportionately harm female and minority workers. And I think one of the stats that really has stood out in my mind is that stricter non-compete enforceability lowers earnings for non-white workers by twice as much as for white male employees. So it really maps onto some of the existing inequities in the labor market. So I know our time's coming to an end here. I want to ask you to put your crystal ball in front of you, put on your forecaster hats. One of the other developments here that's new is that for the first time we have an administration that actually campaigned on non-compete reform as one of its policy priorities, and they have a bill in the Workforce Mobility Act, a bipartisan bicameral bill that we'd love to see them pick up and run with. So, what is the path forward here legislatively? What can our audience do to help? I think would be one of the big questions we'd love to hear you talk about. But as you think about the legislative calendar in the year ahead and in this Congress, what's the best path forward for this legislation, and why does it have a fighting chance? I would start with the fact that it's not a big spending provision in a time when economic policies that benefit workers, boost wages, innovation, et cetera, those are hard to come by in free form. So what beyond that? What do we think the best chances are here?
Well, you offered the value propositions, and I think Chris and I have also sort of underscored those throughout the course of this back and forth exchange. But I would just encourage all the viewers, all the listeners to play an active role. I imagine those who are watching have a measure of credibility with their legislators. They're subject matter experts, either in their area of business or in economic matters, economic development. And so be prepared to bring this legislation that I do think has a real chance of passing in the next couple of years to the attention of our legislators, because there are many competing priorities that demand our attention. Make these arguments, and to the extent there are reservations that any senators or members of Congress have, ask them to vocalize specifically what reservations they have, because we may be able to accommodate those throughout the course of this legislative process, and perhaps even come up with a better work product that, once again, liberates our workers, leads to a higher rate of dynamism, and growth and opportunity in our economy. So engage. make phone calls, make visits to your legislators, show up at their town hall meetings, and establish that this is a priority.
And the good news is that the coalition that we've assembled on this bill, sort of points to possibility. I mean, it's probably the only piece of legislation in the Senate that is a Murphy, Young, Kane, Kramer exercise. You probably won't find the four of us aligned on a lot, but we're aligned on this. And so I think it gives an opportunity for sort of members to to sort of open their eyes and think about joining in a way that we might not have.
Have you noticed that Senator Murphy has been very careful to dissociate himself from me and on multiple occasions? But I appreciate that. We are actually very good friends, but we have some principal disagreements on some different things. But he is a fantastic legislator, and I think we're going to get this done.
It's an open secret that I've actually worked together on a lot, but this is I think this is there for the taking, in part because, as you mentioned, we're going to debate workforce training this year, so we're going to have a debate about workforce and whether this passes as a standalone piece of legislation, whether this passes as part of that package. We're going to likely have this conversation, so there's a place for it in this year. And stories, I think, are also really impactful. That even if you're not willing to sort of let your story be public, because I know how sensitive this is, just sharing that story, your member of Congress will respect your confidence. But the stories are really compelling, and so passing those along is part of your advocacy.
We'll leave it there, Senators Chris Murphy, Todd Young. Thank you so much for your work on this, for your leadership on this issue. And for making time for this conversation today. We appreciate it.
Thanks, John.
Thank you, John.
Great. Well, I hope you enjoyed that conversation, and thank you again to Senators Murphy and Young and their staffs for joining us, or for making that happen and joining us in that conversation. I will now turn it over to Jordan Weissmann, Senior Economics Writer at Slate, to kick off the live portion of our event with our esteemed panelists.
Catherine, thanks so much. Right before I reintroduce our panelists, I want to go through a few statistics, just to make sure that everyone who's listening and watching right now has a strong sense of just how common non-compete agreements really have become. Because I think we've all heard the horror stories, things like the tale of Jimmy John's sandwich makers being forced to sign them back in the day. But I mean, these have really become just ubiquitous in the American workforce. An analysis based on 2014 data, for instance, concluded that 38% of Americans had at some point in their lives been subject to a non-compete agreement, and that 18% currently worked under one. They were most common with highly paid employees, but even about 15% of Americans earning between $20,000 and $40,000 had signed a non-compete agreement. I mean, it's a large percentage of those kind of lower wage worker or kind of middle wage workers. And since then, businesses have likely become even more aggressive about using these contracts. The Economic Policy Institute, for instance, found that in 2017, about 50%, 49.4% to be precise, of business establishments required at least some of their employees to sign a non-compete agreement. And they believe that between 28% and as many as 47% of all private sector workers were subject to one. So the point of those numbers that I just threw at you is that non-compete agreements are basically everywhere at this point. They are not some niche regulatory issue. They are a fact of life for millions and millions and millions of workers, which is frankly why we are here today to talk about them. So I'm very happy to have our panelists with us. First, just again, we have Professor Rachel Arnow-Richman, who is a law professor at the University of Florida, who's written extensively on state level reforms in the non-compete space, and she's involved in the Uniform Law Commission effort to create model state legislation on this issue. We have Najah Farley of the National Employment Law Project, who recently testified in favor of DC's expansive ban on non-compete agreements. And we have Eli Lehrer the president of and founder of the R Street Institute. I want to go through a couple quick round robins with all three of you, but to kind of start this off. So to begin, I just want to ask how you personally got interested in non-compete reform and why you think this is a pressing issue right now. Najah, let's kick it off.
Yeah, I was like, oh no. Sure. So I came to this issue from my experience at the New York Attorney General's office, where I worked with Terry Gerstein in the Labor Bureau, who I think she's speaking in another EIG webinar later this month or next month. And I had the experience of working on investigations, but also talking to many workers who called the office to complain about how they were being impaired by these agreements. And I think I was moved by both the stories that they told and came to understand both from a personal level how fundamentally unfair the agreements were for the workers who were complaining, many of whom were just looking for a new job and unable to move on from their current workplace. And so since I joined NELP, I've continued to work on the issue through working with state lawmakers and policymakers to see, more reforms and hopefully eventually a federal bill will pass.
Eli, I'd like you specifically also to kind of explain why you think kind of your fellow conservatives should be interested in this issue, since you're sort of our representative from the right side of the aisle here.
Yeah. Adult lifetime member of the vast right-wing conspiracy, Civil by Heritage, AEI, you know. So anyway, I think there are a few reasons why this should interest conservatives. First, this is a clear market failure when non-competes are offered. When one employer starts offering them, it becomes an incentive for all employers to, even though it's clear that the market as a whole, as both senators were saying, works better. From somebody who is skeptical of many government interventions, you want a clear market failure. And this is a clear case of one. So that's number one. Number two, there is a strong argument simply on its merits. It has two separate harms, both of which concern many conservatives. First, it certainly brings down wages individually and does immense harm to lower skill workers. For higher skill workers, I'm not sure if it impacts wages all that much, may even raise them slightly, in fact, to have non-competes. But what it does do is it hurts innovation in the economy. There's a reason why Silicon Valley is in Silicon Valley and not around Boston. California has no non-competes. So
that's the sort of the classic comparison that that people bring up in this discussion. And Professor, how did you get involved in this issue, and what makes you feel it's a pressing one at this moment?
My interest, similar to Najah's, just came from being an attorney. I worked for corporate clients on the management side. What I saw over and over again were agreements that came across my desk that were capaciously drafted and appeared to be form agreements. And I think this dovetails with my interest in non-competes as an academic. I teach in the area and write in the area of employment law and contracts. And there's nothing about non-competes formation and drafting that really accords with what we think of as being a reasoned, bargained agreement that is the prototype for contract law. To Eli's point about the market failure, there are really two market failures here. I think that a lot of folks are concerned about the externalities of these agreements, how they affect innovation and third parties and so on. There's also a market failure in terms of the dyad, the employer and the employee who sign them. It's not to say that form agreements are necessarily bad, but these form agreements are being drafted really without any meaningful information on either side as to how they will be used, how an individual's career is going to develop, at what point they may be called upon to be brought to bear on a particular departure. And so circling back to my work in the real world of attorneys, I saw how these operated, which was to throw a monkey wrench in decisions long down the road from when they were signed. In effect, when a company was interested in hiring a new worker who was bound by a restraint, and the inability of that worker to take the next step in his or her career, and for the new employer to be able to, in effect, offer attractive terms and make that sale, so to speak, to a new worker. And so that was where my concern came generally. And I continue to think that it is a pressing issue for all sorts of reasons. I think one of the things that's interesting is in listening to the senators, we're talking now about the pandemic and the effects on employment. Obviously, concern about non-compete dates from well before then. These agreements have been around for hundreds of years. In the most recent set of reforms, the interest, I do credit the Jimmy John stories, the work of the Washington Attorney General and so on. But what, in terms of getting it on our radar right now, but clearly at this point, this has a life of its own.
And, you bring up the lack of negotiations. It just, one of the most striking statistics I saw when I was kind of reviewing the lit on non-competes, I think it was only about, I think in one of Evan Starr's papers on this, we found only about 10% of workers said they actually negotiated these contracts of all the ones handed out. So when you say that companies are just sort of churning out these documents, I mean, that it's not just, it's your personal, observation as a professional, but also it just shows up in the survey data. That appears to be what's happening. So I want to start off by now asking each of you for what your ideal reform for non-compete agreements would be. What would be your ideal way to deal with the situation? And how does the Workforce Mobility Act stack up against it? Let's start with Eli. Let's go with you first.
My ideal reform would not be that far from the Workforce Mobility Act as it's proposed. I think, if anything, you have to look at some special cases, I think, which I'm not positive it deals with in its current form. I think it's a pretty good bill. I don't have any major criticisms of it, to be honest.
And what are the key exceptions that you think need to be in there for the sake of a workable bill?
Sure. So first, sales of businesses, obviously. And I think, if I remember correctly, and I don't have the text in front of me, the bill limits non-competes to 1 year. I think it probably needs to be longer than that to let people sell their businesses at full value. I think if you're selling a business, I'm less concerned, frankly, about people who have a lot of negotiating power when they're signing these things, their ability to sign them. I think that they're tremendously unfair to the lowest skilled workers. I can't remember if the bill is written forbids offering non-competes at all, because California, they can be offered, they can't be enforced, but they can still be put in people's packets, and they think they have a non-compete.
That is, I do not know that detail off the top of my head. I guess we could double check.
Yeah, I don't remember. I think the version, I have to say, the last time I read the whole text was a draft of it. It wasn't whatever was proposed. So I think it's very important that it be illegal to offer them, because for low-wage workers, it's probably pretty rare that they're actually going to try to enforce. So I'm sure it's happened, but it's pretty rare at the lower end of the spectrum. But simply offering it probably does almost the same thing in many cases.
And that actually gets to an issue, which is that even in states that have, even in California, about almost a third of businesses say they try to make some employees sign them, which is remarkable considering they can't be enforced. But
there are totally reasonable things that may have some parts of a non-compete that may have served some of the functions for an employer quite legitimately. For example, if you're provided education by an employer, they pay your tuition, and you leave very quickly thereafter, they should have the right to ask for it back. Now, we have to be careful about some of these things. but how much employers can ask for it back. But certainly there could be things that limit employees' ability to do it. But those aren't addressed in the bill.
Najah, how does this? What would your ideal reform be? Would it just be a complete ban, how does the Workforce Mobility Act stack up against it?
Yeah, I think a complete ban would be, ideal with enforcement capabilities and also private right of action. And I think the Workplace Mobility Act is great. Like, I think that is comprehensive legislation that will remove the agreements for, a large number of workers. And I also, really think that the senators reached out to both like workers who have been personally affected as well as thought leaders and economists on the issue. So I think that is well drafted.
And Professor?
Well, I'll jump on the bandwagon. I think, I really want to credit the senators, and obviously this has been an evolution since I believe Murphy's first bill in 2015. And I really do see that the legislation has evolved. For those who advocate for a total ban, and I am inclined in that direction, I think this is great. It makes that very clear. And it pairs the ban with three things that I think are critical, really with respect to any legislation, and that is education, investigation, and of course, what Najah just said, enforcement. And, what you just mentioned, Jordan, about the use of these agreements in places where they are prohibited, points to the fact that we can't just ban. We also have to have an infrastructure to redress violations. And I think that comes at a lot of different levels in terms of information campaigns, which the bill contemplates, private right of action, as Najah mentioned, also in the bill. And then, of course, the role of agencies, the Department of Labor, and the FTC. So in that respect, I think the bill does an excellent job of thinking in all directions about how to not just ban the agreements, but enforce the ban.
Right. It's because, again, the worst thing to pass a bill and then have employers just kind of flout it. That would be that, which is just that would be not a worst case scenario, but certainly a disappointing result. Now, kind of continuing on this vein, obviously passing legislation is often the art of compromise. It requires accepting second best solutions. And so or even third best in sometimes. So I'd like to hear from each of you what you think the absolute minimum reform that's acceptable is. Like, what has to be in a bill? What just, if it's not there, it's not worth doing this, and we should just, keep, and the senators should just keep plugging at it. Najah, what is your kind of baseline for what non-compete reform needs to include?
Yeah, I think that first, well, I don't know if I would look at it as three, but the two most important things right at the outset are to have like a high threshold for who's covered, and also the private right of action for workers to be able to bring a case or have some kind of enforcement action if they are given a non-compete unlawfully. And I think Professor Arnow-Richman will probably talk a little bit about this, but I also think that the nuance between like a ban versus a prohibition on enforcing them is like another issue that states should look at when they're looking at reforms as well.
Interesting, because if they do the prohibition on enforcement, that leaves open the possibility that they'll use them as an intimidation tool, essentially.
Yeah, and I think like that the private right of action goes to the issue of workers are not always brought up. There's not automatically a case brought against them for violating the non-compete, but employers use softer methods like a cease and desist letter to them, to their new employer, to say like, hey, like, you hired someone who has a non-compete, like, what are you going to do something about that? Which may lead to that person being fired, or anybody gets a letter from their former employer saying like, okay, we're going to bring a case against you, like automatically that puts people in like extremely stressful situation. And so if you have like a prohibition on enforcement, those types of methods can still be used to intimidate workers who are trying to, move on to a new job.
You said that you think that any bill needs a fairly high threshold for who cannot be covered by a non-compete. States have sort of been all over the map with this, everything from $30,000 to $100,000 as the salary limit. What do you think is an appropriate level?
I mean, I was really thrilled with like the DC $250,000 or so for doctors. Like I thought that really like was a great level. I don't know. I think I've seen like so many conversations about $100,000 as the level. I'm not exactly sure. I mean, the economists probably have some reason for why that is. This has definitely been that situation where like the law and economics, that's not my necessarily where I come at this issue from. So it's been interesting. Like I think like one of the first speaking engagements I had on this was at the ABA antitrust conference, where like the conversation was like really into like the weeds of incomes and wages and like all of the economics behind it. And I mean I understand more of it now, but like I'm just saying, like, that's not my expertise, but I think that like when you set it high enough that workers who are the workers who are making $250,000 a year may be able to find an attorney to help them, counsel them, pay for like the opportunity to have someone review those agreements. Whereas you're talking about somebody else who's just basically even above workers in low-wage industries, but beneath that threshold, they're going to have a problem. They're not going to be able to access that help or access those resources as quickly.
I actually, it sounds like you're kind of formulating a rule of thumb here, which is interesting, which is, make it a level that the person can afford counsel to actually negotiate. That's kind of to negotiate one of these agreements. That's sort of what it sounds like. It makes sense. And since, Professor, I guess, Rachel, you talked about negotiations before. I guess that's a segue back to you. What do you think needs to be the minimum reform? What makes sense to you?
Well, there are so many things on my wish list, and some of them are what I mentioned before about the current Workforce Mobility Act in terms of the resources put into education and enforcement. But I think, any non-compete legislation that attempts to limit not just the population who signs non-competes, but also the scope of the agreements needs to be pretty mindful of the practice of judicial reformation. And so the number one requirement on my list, I would say, is a law that eliminates what's sometimes called blue pencil or judicial modification, which is a rule that allows judges to reduce the scope of overbroad agreements. And this is an incredibly pernicious rule in the sense that it creates strong incentives for employers to overdraft. That is, to rely on courts to take agreements that would otherwise not be enforceable because of their overbreadth and sculpt them for the situation at hand. And so employers can essentially, and given the absence of an enforcement regime and private right of action as it stands in states where there is no legislation, that means the employee can be taken to court on an agreement that on its face is overbroad, and suffer the litigation and the cost of that litigation, not to mention the loss of the job that prompted the defection. And the employer, even if the employer overreached, can walk away with a binding restraint and not have to pay anything for the trouble. And so what I would like to see in any legislation that permits non-competes in any respect to eliminate judicial modification. And what I would, that'd be sort of first. And I think second with that, I would like to see, again, in terms of encouraging employers to really take the initiative and think carefully about what they are asking for with these agreements, rather than simply draft capaciously and use them as a tool across an entire workforce. But to think about what they really need. And this can be done effectively, I think, by requiring an employer to use the least restrictive means as possible. So that's a second on my wish list / requirements. What we know is that, it's not only non-competes, though non-competes are the ones that have the most damaging effect and consequences on careers and on the broader economy. But there are a suite of restraints that employers use, non-solicit agreements, non-disclosure agreements, and so forth. And so I would like to see laws that permit non-competes put it on the employer to use the least restrictive form of agreement as possible. So rather than bar an employee from working because he or she has sales contacts, bar that employee from servicing prior clients that he or she had contact with. And I know you want our answers short and you probably have follow-ups, but there is just one other thing that I would really like to see in every legislation on the issue of notice and enforcement. And this may go actually, Jordan, to one of your next questions, but I think we need to do more than notify employees that they will have to sign an agreement. And I think we need to do more than give them a copy of the relevant law. I would really like to see a plain summary developed by agencies, and perhaps this will happen under the Workforce Mobility Act if it becomes law, given the powers that have been invested in the agencies to enforce that act. But a plain summary as part of an information campaign that would let workers know that just because they have a non-compete doesn't mean that it can be enforced against them. And that if they are challenged, that they have recourse. And that if an employer imposes a non-compete that is too broad and a court finds that the agreement is unenforceable, that individual can get attorney's fees and damages for their losses. So that's part of what I think a notice has to involve.
It sounds like, to kind of sum up a lot of what you've just said there, that if we allow non-competes to continue to exist and apply to even a somewhat broad swath of workers, you have to make sure that they can't, that employers can't use them abusively and can't use them to just drag people through court, essentially, to kind of get what they want. And the onus has to be kind of put back on them to use them legally. That there has to be, you have to make sure that the employer, if they don't do things correctly, they're the ones who suffer the penalty, who are punished, not the worker who gets litigated to death. Eli, and now for the last part of this round robin, Eli, your essential reform. What is the absolute key thing in your view?
First I should say, I don't seriously disagree with anything Rachel or Najah said. I would say, though, that the essential thing is to protect lower wage workers. I agree that it would be ideal to have something that went relatively high. But at the end of the day, the people who true and very clear individual injustice can be done to is primarily people who have virtually no bargaining authority to start with. People earning less than the median wage in the area is probably a pretty good standard. So I think at minimum, non-competes should be banned for lower wage workers, would be the minimum.
And so that kind of brings me to my next question I had planned, and we are running a tiny bit short time, but I want to bring it up with all of you, which is, to play devil's advocate, defenders of non-compete agreements have typically argued that they actually do some good for companies and for workers, because companies are more likely to invest and to invest in and train their employees if they know their talent isn't going to walk out the door, and workers actually may be paid more, and if they have a chance to negotiate for a non-compete. And there is some empirical evidence that this is the case. There have been studies finding doctors who have non-compete agreements are paid more, and that professionals who are presented a non-compete agreement before they agree to the job who are aware of it going in. They're not just handed a slip of paper on their, the day they're being onboarded. They also get a pay bonus as a result of that. They seem to make more money. So given that the Workforce Mobility Act really, really would restrict these, agreements pretty heavily, why shouldn't we allow a wider range of, highly trained technical professionals like coders and lawyers and doctors to sign these as long as they're given, sufficient notice and education and allowed to negotiate? Is there a reason why we shouldn't do that? Rachel, you go. You're smiling a little bit, and so I'm curious about your take.
Well, it's a long answer. I mean, let me just say something about academic studies, and I feel like, it's fair for me to say this as an academic. We have to recognize what academic studies are, and that is sort of an isolated analysis of particular situations. And so, we have studies that show different effects, and that's great. It's up to regulators, though, to, kind of connect the dots in terms of what is the best policy. And that best policy has to account for sort of more than just the individual positive effects in discrete populations. So I'm very happy if doctors who sign non-competes make more money, but I'm more worried about their patients. And so that's sort of just one example. I think that everyone can understand that we are not going to just make decisions based on those sort of individual good outcomes, nor can we necessarily know that those outcomes are necessarily because of non-competes. Now, it's true that non-competes incent employer investment, but they're not the only tool that employers have for retaining their talent. I mentioned restrictive covenants of other sorts that do not prevent workers from actually competing in total, but just limit their use of information or contact with clients. So that's, I think, an important example. There is external trade secret law. Again, a reason why employers ought to have incentives to invest. And frankly, I think it's important to kind of go back to the starting place, which is remembering that non-competes are restraints of trade. And our general policy and the senators sort of spoke to this, is that you allow free competition. Now, during the course of employment, as a matter of background tort law, workers can't compete for the most part with their current employer. But we have a policy of employment at will in this country, which permits workers and employers to terminate their relationship at any time. And the assumption is that that means they are free to then work and sort of, align their loyalties with another entity. If employers want to keep workers, they should make them happy in other ways. They should make them happy not by sort of relying on non-competes and invest their own investments in training. They should make them happy by improving their wages, improving their working conditions, creating opportunities for advancement and so forth. So I think it's an overstatement to kind of place everything on the back of a non-compete in terms of the advantages that companies can reap in terms of investment and employee retention. It's more complicated than that, and there are more tools at their disposal.
I'm just noticing that we have hit the 2 p.m. hour, unfortunately, and so I think we're going to have to wrap this discussion up, but it was wonderful talking to you. There are many more questions I wish I could ask, but thank you again to each of our panelists for joining us today. It was a pleasure chatting with you.
Thanks for having us.
Thanks.
Thank you so much, everyone. Thank you, Senators Murphy and Young and all our great panelists and moderators for the great conversation on Workforce Mobility Act and non-compete reform. And as Jordan mentioned, we're really sorry we couldn't get to your questions, but please feel free to send them over to EIG and we will definitely try to answer a few of them in our recap. And as always, this webinar is being recorded, so it will be uploaded to the EIG website along with a short recap and a few key takeaways. But thank you so much, everyone, and we hope you have a great rest of your day.